software hasn't been configured to respect that, kind of reasonable conception that people normally have about what it means to have different accounts on the computer. Technological protections are often some of your best ways to assure privacy where the law kind of fails, and this issue is still being really kind of litigated and hashed out in the courts. It's also kind of a more subtle question as to what happens if you share a little tiny bit. And this was a case that I was involved in before EFF, United States versus Heckenkamp, where Mr. Heckenkamp had his computer attached to a school network just in the dorm room. And the school network had an acceptable use policy that said, well, we, the school administrators, can look at your machine a little bit if we want to ensure the health of the network, but not necessarily for other reasons. And this is a real issue we litigate against the government all the time, which is what is the effect on the reasonable expectation of privacy, and therefore whether the Fourth Amendment has any role to play whatsoever when you've given somebody access for a little tiny for some reasons, but not for all reasons. And the government usually argues that it's an all or nothing kind of thing. Like, I always say it's like inviting a vampire into your house. Like, if you don't invite them in, they can't come in at all. But if you say, oh, come in, but just for a cup of coffee, they can run amok and do whatever they want. And that's the government's view. Like, once you let us in, we can run amok and we can do whatever we want. Once you let somebody else in, you don't have an expectation of privacy because you gave it up vis-a-vis this other person, so you don't have it vis-a-vis the government either. And the Heckenkamp Court in the Ninth Circuit rejected that, and I think went along with what I think is the predominant view and I think is the correct view, which is that privacy is subtle, and we may share with people for certain limited purposes, but limited sharing doesn't mean that we've given up all of our expectation of privacy with regards to the entire world, and the Fourth Amendment has no role to play. Mr. Heckenkamp wasn't actually able, that was the good part of the Heckenkamp case, Mr. Heckenkamp wasn't really able to benefit fully from that aspect of it because he was at a university. And this brings me to the other kind of complicated issue that Kurt touched upon, which is the issue of private search and public search. Thing number one is that the Fourth Amendment applies to regulate the behavior of the government, including state governments and local governments. It doesn't regulate private behavior. Okay, so that's a totally separate category. Private searches, if governed by anything, are governed by totally different stuff. But sometimes you have employers or schools or those sorts of things that are public, like the University of Wisconsin or University of California or the police department or something like that, where it is both public and is serving this kind of private sort of school or employer role, and what happens there. And in those cases, the Fourth Amendment does apply, kind of a modified, sort of slightly watered-down version of the Fourth Amendment, but the Fourth Amendment does apply. And basically functions to say police type of investigations, wrongdoing investigations, are still governed by the Fourth Amendment, but employer or school type of searches, which are for the purpose of that service, those are not governed by the Fourth Amendment. And in the Heckenkamp case, what the court said was the fact that the search was conducted without a warrant of his machine as it was connected to the school network is excused because the university was doing it because they were concerned about the security of their system. They weren't doing it just to investigate him to see who had committed this crime. Of course, who was compromising the security of the system was the same question as who was committing this crime, but the court found under the testimony that was offered that the school's motive was this safeguarding one as opposed to a investigatory one, and allowed the search to stand. This was also an issue in a Supreme Court case that EFF was involved in this last Supreme Court term, which is City of Ontario versus Kwan, where Mr. Kwan was a police officer using his police department issued text messaging pager to exchange dirty text messages with his wife and his lover and another guy. I don't know what that was about. But one of the big issues there was the question of, the police department is both the police department, but it's also his employer, and what rules applied there. Was it sort of the pure Fourth Amendment type of rules, or was it, as the court found in Kwan, one of these kind of watered down things because they were serving this other role, not purely investigatory. It was about the role, it was about the police department as employer as opposed to the police department being investigators. So you can see, I think, with these examples of machines being connected to networks, acceptable use policies, shared accounts, and just the vast amount of intermingled evidence, how complicated how complicated it is to decide how to apply the old rules about searches and seizures to computers. And one of the ways we've tried to address this, or courts have tried to address this, is through trying to set up some kind of things that police can follow so that they understand what's going on. And the Ninth Circuit has really taken a giant leap in this in the case of United States versus comprehensive drug testing. Probably one of the most important computer search cases of the past 5 years. And in this case, the Ninth Circuit set out some rules for officers to follow that it hopes addresses this problem of, once you're in the computer, it's just a free-for-all. You can get access to all the information that's there. So I'm going to just say what the rules of comprehensive drug testing are and then let Marcia talk about border search. One is that the court recommends that investigators waive the plain view doctrine, which is an amazing recommendation. In other words, if you're looking for something and you see something else, normally the cops can seize it if it seems to be evidence of crime, but under comprehensive drug testing, they want police officers to waive that. Number two is that officers should have an alternative search team, either within the police department or independent third-party forensic investigators who will filter through the information to get what it is that they have probable cause to search for and segregate and redact out everything else to retain the privacy of that information. For those of you who are thinking about third-party forensic businesses, it's a growth industry in the Ninth Circuit right now. Three is they should say what the actual risks of destruction are, not this battery might die or digital evidence is so delicate, who knows what could possibly happen to it if we don't search it right now without a warrant, but disclose the actual risks of any kind of destruction or interference with the evidence. Number four, they should have a search protocol that only goes to look for the stuff that they have probable cause for and not for other stuff. So for example, in a case that Marcia and Matt and I have, where they were looking for evidence of who sent email threats, they shouldn't also be searching through everybody's computers for arson or for vandalism or other types of things on a fishing expedition. And finally, the idea that when after the search is done, when you have the stuff that you had probable cause for and you were allowed to search for, and you've got all the other stuff, they've got to destroy or return the other stuff and can't hold on to it in order to fish through it later on if they get bored or that sort of thing. So Marcia's going to talk about the complexities of border search, and then Kevin's going to talk about what happens when you don't have your data stored on your device or phone or laptop, but it's in the cloud. And maybe if we have time, then I'll come back and talk about Rayburg and the Fourth Amendment stuff, or you can talk about it then. Okay, thanks.
Thanks, Jennifer. So I'm going to talk about an exception to the Fourth Amendment that applies at the borders. How many of you take your laptops on international trips? And how many of you have information on those laptops that you consider confidential? Yep. So I hate to tell you this, but all searches that occur at the border are considered reasonable. So Kurt mentioned that the Fourth Amendment protects against unreasonable searches and seizures. And the rationale for this exception at the border is that the government has an interest in keeping bad stuff, illegal stuff out of the country. And so what that means is that for routine searches, they need no suspicion whatsoever to search things that you bring into the country. There is a very, very narrow category of search that's considered non-routine, but it's very narrow. I mean, it's like your alimentary canal. That's what it is. They need reasonable suspicion to do a search like that. In the past few years, there have been several cases that have come up where the government has searched laptops and other digital devices that either are coming across the border from Canada or Mexico into the United States, or at an airport, which is considered sort of the functional equivalent to the border when somebody is flying in from an international location. And the courts have uniformly found that despite the tremendous amount of information on a laptop, a search of a laptop is routine and therefore requires no suspicion whatsoever. So that is something that I think a lot of people probably don't know. and that people should take into account when they're traveling with their laptops internationally. There are a couple of interesting developments that are going on despite this really bad rule. There's a case that's being litigated right now in the Ninth Circuit called United States versus Cotterman. The oral argument will be in September in San Francisco if anybody's interested. This is a case in which a man was driving with his wife from Mexico into the United States, and the border guards ended up seizing his computer and his wife's computer. They didn't have the tools to do the sort of forensic analysis that they wanted to, so they took those computers 170 miles away to do the search, and they kept them for 4 days. And the district court in that case found that actually the government needed reasonable suspicion in that case to do that, because they actually took the computers so far away for so long that the government lost its border search status. So this is a really interesting situation. I think it creates some issues for the government, because it basically means that if they want to be able to search a computer on no suspicion, they need to do it pretty much on site and very quickly, which may logistically be difficult and may not really be feasible in all situations. But so this is a chink in the armor, at least, and we'll see what happens in the Ninth Circuit. There have been a couple other district court decisions that have followed Cotterman at this point, so it's going to be interesting to see if that holds up. Another thing I wanted to mention that has come up in the border search context that is not necessarily tied to the border, I think it could also come up in other contexts, but it just happens to have come up in the border search context, is the question of compelled disclosure of passwords. There was a case a couple years ago involving a man named Sebastien Boucher, who was coming from Canada into the country, and his computer happened to be on. Agents were able to go through it and see some of the content. There was some that they found to be questionable. They suspected it might be child pornography. They shut down the computer, and later, when they tried to boot it up again, they realized that the drive that the questionable content was on was encrypted. And they tried to force him to give them the password so that they could access that information. And the court in that case found that to force Mr. Boucher to give over his password would violate his Fifth Amendment right against self-incrimination. Now, the Fifth Amendment right against self-incrimination says that you cannot be forced to give testimonial evidence that would tend to incriminate you. And so they basically said that forcing Mr. Boucher to give his password would reveal the contents of his mind, his knowledge as to that password, and that would tend to incriminate him, and they weren't allowed to do that. So that is also a very interesting precedent. That one stands. It was not appealed by the government. There's been another case since then in Michigan that followed a similar reasoning. So that's another kind of interesting and developing area of border search related law as well. So that's what I have for you, and now Kevin's going to talk about the statutory protections for email.
Hey everyone, thanks for coming. Actually, I'll start with a brief discussion of the Fourth Amendment when it comes to the data you store in the cloud or with other third-party providers. 40 years ago, the Supreme Court found that you had a reasonable expectation of privacy in your phone calls. Despite the fact that the phone company had access to those calls, could listen in on them, that it was carried over this third-party company's equipment, you had a reasonable expectation of privacy, and the government had to get a warrant, actually something we colloquially call a super warrant, a wiretap order, if they wanted to listen in on your calls. We at EFF think that that logic clearly applies to your electronic communications as well, your emails, your IMs, et cetera, et cetera. The courts, unfortunately, have not quite caught up with our enlightened view on the subject. Instead, the courts have tried to avoid answering the question of what Fourth Amendment protection you have in your electronic communications. This was most recently demonstrated in the Kwan case that Jennifer mentioned, where the Supreme Court said, well, this technology is so new and we're not quite sure of society's expectations regarding it. So we're just not going to decide whether you have a reasonable expectation of privacy in your pager text messages.